Stay tuned for Time to Talk with host Jennifer Graziano of Zion Memorial Chapel and Cox and Graziano Funeral Homes. Jennifer is here to discuss a sensitive subject we all need to talk and think about. Here now is Jennifer Graziano and Time to Talk.
Good morning, Westchester. It's 9 a.m. on Monday, and that means it's time to talk with me, Jen Graziano. I'm a licensed funeral director who oversees my family's funeral homes, Cox and Graziano of both Mamaroneck and Greenwich, and the Zion Memorial Chapel of Westchester. Every Monday, I come to you discussing important topics and sensitive matters that all of us need to pause and reflect upon, and through this show, I hope to provide a platform to do so. So this morning, I am joined by Michael LaMagna. He is an elder law attorney and estate planning attorney, a partner in the firm Riker, Danzig, primarily based out of New York, with offices both in Westchester and Stamford, and Mike counsels families on complex financial and estate planning issues. He will walk them through life-changing situations, times where we have to stop and reevaluate what our plans are going forward. And in light of the current climate that we're living in, what better time to take inventory of our legal and administrative plans and see what needs to be tweaked, what we're lacking, and what we should do going forward. So good morning, Michael.
Good morning, Jen. Good morning to all your listeners.
Thank you so much for joining me. We're working together currently on an organic group that's spread out of providers to the senior community in ways that we can work together, help each other, and help seniors navigate through these complex times. So it's a pleasure to have you on the show to talk with you specifically in more depth. I want to begin, Michael. Let's talk about overall, what are you sensing in your office amongst your clients right now? Is it, is it a climate of panic that you're seeing? Do you find that people are lacking documents such as healthcare proxies, healthcare directives, advanced directives? When we look at our legal affairs in relation to COVID-19, is that the biggest challenge you're facing right now?
Families are facing a number of challenges. It's hard to think of one specific because emotions are in flux. And I wouldn't say panic as much as uncertainty. And, uncertainty about, what's going to happen tomorrow or next week. And a lot of people are wishing that they had started their estate planning earlier. And I always tell people, look, the right time to start the estate planning is as soon as possible. You can't do anything about yesterday, but certainly you can do something about today. And, I'm working very closely, with a lot of the other organizations like yourself and, trying to educate people and make them understand what these documents mean to them. And you of all people, Jen, because of what you do, know that people are often fixated on what happens when I pass away. We're more fixated on what happens to you now. What if you get sick now? What if there's an emergency now with you? How are we going to access, healthcare and you access your funds to care for you if something should happen now? So I think there's a big misconception out there that they only need documents after they pass away, and people don't understand that it's really important for healthcare decision making and financial decision making now while you're alive. That's what's the most important, especially in light of what's going on with COVID. A healthcare proxy has gained new momentum, and that's the document that basically says when you cannot make a healthcare decision for whatever reason, infirmity, what have you, incapacity, then this is the person, this is the agent, this is the person I most trust to make decisions for me regarding my health care. And then the living will is a corresponding document that says if I'm in a incurable, irreversible situation, I would or wouldn't want to be kept alive by extraordinary measures. And these documents are only as good as the people that are working together on them, meaning that, especially in light of COVID, it's really important that people get very granular with what their wants are. And because I've been a nursing home administrator for over 20 years, I've been working with families for a really long time on what is it that you want, not what your spouse wants or what your family members want. But if you're in a situation, in a medical emergency, what is it that you would want? And who are those people that are going to make decisions for you and the people that you've spoken to about the important decisions. So it's much more of an education process. And one thing I don't think is helpful is there's a lot of misinformation out there, and B, there's a lot of panic. And my job from very early on has always been to take the panic out of the situation and, dealing with what's going on right now in your life. So, there's no scare tactics. People often feel like if they do their estate planning, something's going to happen to them. And I take that right off the table. And I said, nothing's going to happen to you other than you're going to feel more secure and you're going to be encouraged to speak to people, those people that you're going to be selecting for these very important jobs, about what it is that you've decided and how they're to handle things.
Well, Michael, I'm always a huge advocate, first of all, of when you're dealing with these matters to seek counsel of a much heightened expertise such as yourself. Your background is quite unique. In addition to receiving your law degree, you also have a postgraduate degree in gerontology. So you're very well versed in matters affecting age-related issues. Like you said, I think right now there's such panic and the crisis has set in. And the time to make your plans is really never when the crisis sets in. That becomes reactionary. The time to really make your plans is when you're healthy and happy. And that's quite the paradigm, because those are the times that you don't want to think about the worst case scenario. But those are also the times when you have the most clarity of mind and you're going to make the best decisions, the most informed and educated decisions. When we react, it's certainly a different outcome than when we prepare. So I think, the message what people should take away as we start to emerge on the other side of this pandemic is that it's time to get affairs in order, because the what ifs can very easily become reality. I think what I want to discuss, though, we've mentioned healthcare proxies, and that's something that, has really spawned, new life in light of this. But the geographic barriers that have been imposed of people who may have been their parents' healthcare proxies but could not get to the healthcare facilities. Family members are not admitted into hospitals. You cannot get into a nursing home to see your loved one. So what happens there in light of these special extenuating circumstances? And what about the need for backup agents and backup proxies and backup secondary fiduciaries to people, because Plan A didn't necessarily work during the COVID crisis?
Well, okay, so it's two separate issues. Let me deal with the second issue first, regarding backups or successors. So my procedure has always been to have at least 2 to 3, even 4 or more successors. So successors are people that if the primary person, for whatever reason, because of illness, somebody passes, somebody's life situation, they are unable to perform the job, then there's a successor person. And one of the things I often see, I review a lot of other estate planning from other attorneys when people come in, and I encourage people to show me their estate planning documents, because it's not just people that don't have anything, but there could be things that have changed in your life, or there may be insufficient documents that you may have that you think are going to do something for you, but may not. So I always tell people, look, so what you need to do is you need to think about several people. Have a primary, secondary, tertiary. There's no number. The law doesn't say you can only have 2 or 3. I want you to think about the people in your life that are going to make the decisions that are important to you, that are going to make those decisions. So often I spend a lot of time with people, and I said, well, okay, tell me about the person that you're proposing. And they'll say, well, they'll never, I know that they'll never do X, Y, and Z if they're in that situation, an end of life situation. I know that they'll never do what I asked them to do. And I said, well, then that's not the right person. So, it's not just getting documents off of the internet. It's talking to people and explaining what could happen in that instance, and then explaining how you need several people in case something happens. And while we're on that CMS, what you're talking about is the CMS guidance that said that they're about visitation. There were carve-outs to that CMS visitation guideline for nursing homes and other healthcare facilities for compassionate care. We've worked with families, especially because I know I run several nursing homes and other facilities in both New York and Connecticut. We work with families in different types of situations to get in contact with their loved ones during this time. Early on, I was surprised at how many clients were calling me saying, look, we have this situation and we need to, my husband will never eat unless there's somebody there besides him. Different types of situations. So we instantly started utilizing technology to put different types of technology into the different facilities, working with putting private aides in the facilities, working with facilities in the recreation department to have FaceTime and portals and all of those sorts of things. So it's been very challenging, to say the least, but we've worked hand in hand with the facilities. Myself, more than anyone else who's run nursing homes for 22 years, understands what's going on there. And I don't mean to minimize it, but also people have to advocate for their loved ones. And so we've been very creative on how we're doing that. And also enforcing the CMS guidelines. CMS, Center for Medicaid and Medicare Services, was clear that that people's rights to have visitation in different ways hasn't been diminished, it's just changed. So, utilizing technology has been wonderful for people. The other thing I want to make sure that we talk about, Jennifer, is that we've been, lawyers now are able to do things like e-notarization and e-witnessing. So
yes, I want to talk about that. I want to talk about the new way that we're going to execute documents in light of that came up on our call the other day. But I also want to relate it to seniors who, not painting with a broad brush, but not all have that same technological capacity. I mean, some can just blow you away and probably are better than I am with my iPad. But what are the new guidelines regarding remote execution of documents and electronic authorization, and how is this being taught and communicated to the seniors who need this?
So Governor Lamont in Connecticut and Governor Cuomo in New York both came up with guidelines regarding e-notarization, so that's notarizing through technological means like Zoom and Skype or even FaceTime, as well as witnessing. Because different documents like the power of attorney and healthcare proxy require two witnesses, and the power of attorney and the will also require notarization. So now we have guidelines, and now we've come up with policies and procedures to make sure that if we're doing notarization, witnessing of different documents like a power of attorney, healthcare proxy, or will, or even trust, we have the seniors understand. We go through it step by step with them. We make sure that they're safe and they understand that what they're signing. Is it for everybody? Absolutely not. Is it for people that have a basic understanding, or they have a caregiver that's with them that has a basic understanding of the technology? Yes. So it's an individualized approach. Sometimes, though, if the person is not able to do it for whatever reason, we just had a successful session, with the senior, who was on a vent, but also, was able to understand what I was going through. And so it's per person, and they have to have a basic understanding of what's going on. But for some people, it's not going to work. And in those instances where it's not going to work, we have to look at more extreme measures like guardianship or conservatorships, which is where the court comes in. And the person isn't able to execute documents. When you need to make healthcare decisions or financial decisions for people that are alive, sometimes you have to go to the court system, which is still working for emergency measures like guardianships and conservatorships.
My other question to that is, the efficiency of the legal system right now, the ability of courts to intervene, the timing. I'm sure while they might be open, well, I hope, but I'm sure that has to be impacted. And secondary to that, what type of deference is the court giving now to these documents that if they were not properly executed, so to speak? I mean, I know with wills, we always look to the intent of the testator. If they're falling short of, the legal I dotting and T crossing, are they still given their proper legal merit?
So they have to have the T's crossed and the I's dotted. There are some wills that are very, very old, over 25 or 30 years that sometimes they're deferred to differently called ancient documents. But for the most part, even with e-notarizing and e-witnessing, things need to be done a certain way. I recognized early on, not only did you need the guidance from the governors, but you also needed policies and procedures, which we had for the old way of doing things, which we now have for the new way of doing things. So, even something simple like scanning the camera or the computer if they're on a computer to make sure that there's nobody else in the room, so we know that there's no undue influence. The other thing that we're going to be doing is after things are lifted, people are going to have the option of coming into the office and signing those documents over again, so that they're, we know that they were done properly the first time and the second time. The courts have been wonderful, Jen, and hopefully if there's anybody who's listening right now, things like guardianships and end of life decision making have had huge difference in the court system. I'm a guardian to two people, which means I make the legal decisions through the court system for their health care and their finances. And both people got COVID, and both people I had to have an end of life decision making through the court system. And both court systems worked with me very closely to come up, as well as the families and with the institutions that they were in, the hospital and the nursing home, to come up with solutions. But the court system was right on it.
That's refreshing to hear.
Yeah, but however, you also need to understand that if it's a non-emergency, don't put it before the court, because the court is only hearing things of the most emergent nature right now. So you don't want to flood the court system, just like you don't want to flood the hospital system with non-urgent matters right now. You don't want to flood the court system. So I think it's up to all of us, to make sure that we're only putting the most important things before the court first.
Absolutely. Circling back, though, I think, again, the overall message as we come out of it is preparedness. We'll realize now what we should have had and perhaps did not. Going forward, how do you think COVID-19 will impact how you direct your clients from this point forward? What documents should everybody have? And again, how will it affect the nature of your counsel to your client?
It's interesting. I've always planned for the unplanned. And the uncertain. I'm not really sure it's going to change a lot for me. I think it changes the conversation that the clients have with me. But the way that I handle things, meaning that, I spend the time with the clients. I don't charge for consultations. So, people are free to come in. I look over their documents. I tell them, look, it's not just now theory where I'm saying to them, this X and Y can happen. I think there's a realization that the things that I've been saying could happen have happened. So now I think people have a better sense of urgency. But, I see my job as counseling people, for their decisions. It's not my decision. I just tell them what's available to them, and they then make the decision about what they want and reflect their decisions. I think that there's just more of an understanding that these things may happen, and if they do, then this is the roadmap for them, for the people to take in their lives. I'm not sure it's going to change a lot about how I approach things, but I think in my approach, how clients respond back. I thought I was going to be flooded with people, saying, I need to get this done tomorrow. And instead, it was very steady, and people were saying, I understand, that I need to get this done. Tell me about this. Tell me more about this. Because you're right, you never make a good decision when you're under pressure or under the gun. We have had, my whole career, I've always had those situations where people, have had deathbed wills or things of that nature. And I believe very strongly that people that have capacity have a right to make the decisions for themselves all the way up to them passing and then thereafter. So it's always really important as well.
Yeah, no.
Yeah, that's always been my mantra. I think the best gift you can give someone is the gift of following through when they can't make decisions or after they pass away.
And the alternative, the best gift you can give to your loved ones that you leave behind one day is having had decisions made and eliminating the guesswork for children and whoever you're next of kin may be. I want to talk a bit about the Medicaid process, the application process, how that's been impacted, and an interesting issue that comes up on my end. Many families come to us with we create irrevocable trust as part of satisfying that Medicaid requirement. And as you know, overages in the account is sheet back to the state. It's interesting now because in light of COVID and in light of the executive orders from the governor that wakes haven't been permitted, traditional funerals haven't been permitted, the archdiocese has suspended masses, there's a lot you're going to run into the situation of funeral homes where monies in the account have not been used, not by choice of the family. Is that money now to go back to the state, to the county, or are there provisions for a family to share in the overage because, again, it wasn't their decision not to follow the funeral arrangement?
So one thing I always speak with families about is doing a burial trust, whether it's for Medicaid or not. And the reason being, once again, the best time to do something isn't when you're under pressure. And what I tell people is, you're gonna do it. You're gonna get it done now, so that when your loved one passes away, you don't have that stress on you. You make a phone call and everything is already taken care of. So you don't have to pick. One of the saddest things is having to pick a casket for somebody right when they pass away. But to do it a couple of years before, it's sad, but a different type of scenario. As far as the Medicaid process, unfortunately, during the COVID crisis, we got some news that the Medicaid process in New York was changing. And right now, until October 1st, 2020, there's no look-back period for home care Medicaid in New York. There's only a 5-year look-back period for nursing home care. So what that means is, there were always ways to access home care for people without a look-back period or a penalty period. Now, after 10/1 of this year, there's going to be a penalty period. So it's now re-educating people about what the new process is going to be and how the penalty period is going to affect them and their ability to get home care. As far as the irrevocable burial trust for Medicaid purposes, they are irrevocable, meaning you're paying for X, Y, and Z. And I understand that they weren't able to get all of the services that they might have paid for. However, I think several funeral homes are doing memorials and things after the fact, which will then encompass some of the things that they weren't able to do. There's been no directive by the governor's office or HRA or Medicaid DSS on that overage. And I don't know that there will be, but I do believe that the money will just be spent in a different way.
And I agree, but to an extent. I mean, without replicating, for example, you can have a memorial, but it is interesting. I'm sure it eventually will all balance out, but it's going to require a lot of auditing, case by case, contract by contract, for sure. Michael, once again, I encourage all listeners to know that when you're dealing with matters of estate planning and elder law, you cannot just go to any attorney. It has to be someone with a heightened specialty in these complex issues. Like you just mentioned, they're ever changing, especially laws pertaining to Medicaid, and a new law that falls upon us in October in New York. It's going to be a long time before we fully emerge from this crisis situation. So people are going to be pressed to get the proper education in a short amount of time. You need to go to a trusted expert, and you certainly are that. With your background in gerontology, your years spent in the nursing home healthcare sector, and your law practice, you really run the gamut of age-related planning issues. So I encourage people to get in touch with you. How can they do that?
I'm sure they can just call. We're open. I've been working to ensure that families get the things that they need all along. So they can call me directly at 914-539-3365, or they can email me, and it's LaMagna. It's MLAMAGNA at Riker, RIKER.com.
Well, Michael, again, I know I'll be speaking to you tomorrow, but that's 914-539-3365. And I think, again, among our messages this morning is that it's never too late to make a plan. And making a plan isn't creating an omen, it's exactly that, making a plan. And for all the great life events that we go through, you always make a plan. End of life, aging, and healthcare, although they're harder and more sensitive issues, they still require that same focus and effort. And do it while you're healthy. Do it while you can. Do it when you can have the family at the table, collectively talking and sharing ideas. But always make sure that your wishes are carried out. It's so important, and what's going on in this world reminds us all the more of the need to make a plan.
And Jen, thank you very much. I mean, I think it's important that people get the correct information out there, about all of these types of issues, and not just seniors, but younger people as well, so that they understand. Unfortunately, with COVID, had several people in their 40s and 50s and 30s that had COVID, and we're sick. So you don't, and you know what? You don't know what's going to happen. You go outside, you get hit by a car or what have you.
It's sad but true. On that note, Michael, though, our time has come to a close. I'm so sorry, but here's just Michael LaMagna, and this is LaMagna. Thank you for taking the time to listen. These are the time to talk. Have a great day. Bye.